friction between the government and judiciary over the appointment of judges and which parts of the constitution can be changed by Parliament took a sharp turn on Sunday, with Union Law Minister Kiren Rijiju citing comments by a former High Court judge to underscore which view he considered sane. The Supreme Court has hijacked the Constitution for the first time. They said, we will appoint judges ourselves, the government will have no role. This is what the retired Delhi High Court judge R.S. Sodhi said in an interview to a YouTube channel. Now, posting the video clip of that interview on his Twitter handle, Law Minister Kiren Rijiju wrote, a majority of the people have the similar sane views. He went on to say that all our three organs of our state, that is the legislature, executive and judiciary, must work together in the larger interest of the nation. Well, to talk more about this tussle that we've been seeing, we're now joined by Aashutosh Srivastava, advocate with the Supreme Court, someone who supports the government, and Kapil Madan, advocate at Supreme Court, who does not agree with some of the government's policies there. Well, Aashutosh Srivastava, first to you, what do you make of this very public tussle that we're seeing, the various statements that have been made over the past couple of weeks and days about the basic structure, and then about the appointment of judges, with the law minister sharing a video clip and a call saying that the majority have the same view?
I would like to state that, Article 124 deals with the appointment of judges in the Supreme Court, and Article 217 deals with the appointment of judges in the High Courts of India. Now, the issue is that in any of these articles, there is no provision for the collegium system. So, how the collegium system evolved? Article 124 says that the President of India has the power to appoint the judges of the Supreme Court in consultation with the Chief Justice of India. Now, this consultation was an issue which was decided finally in 1993 when, the Supreme Court Advocates on Record Association versus Union of India, this matter came up before the Supreme Court. The Supreme Court stated that the decision of the Chief Justice will be mandatory for the President to follow. However, the Constitution doesn't speak anything about that, and that, I think, is the issue, because
all right, so the issue about the way the collegium is appointing judges, there's no transparency, there's opaqueness, but do you think this is the way to, these are very important issues, and this kind of public sniping by, first you have the Vice President talking about, how he doesn't agree with the basic structure and, holding forth at length about it, and then the Law Minister, time and again he's been tweeting and sharing these video clips. Is this the way to find a solution to this issue?
See, the Law Minister is saying that this collegium system is neither, the constitutional provision nor it's a parliamentary provision. This has been adopted by the Supreme Court itself by its own judgment in 1993. So whether these kind of judgments by which the Supreme Court itself makes the laws as to how, in what way the Supreme Court judges will be appointed. So that is the question, whether the Parliament has any role or not, whether the Constitution will be superseded by the judgment.
Again, understood that these are the issues that are at hand, but again, the way that that the government is going about this, Kapil Madan, your views on this?
So, my understanding of the situation is, it appears to me that this is a calibrated, debate done by the government, because we saw how Mr. Rijiju started this conversation, and thereafter we saw Mr. VP Dhankar, after becoming the Vice President of India, he again started questioning the basic structure doctrine. Now let's all go in the history. Mr. Dhankar was a lawyer himself, and he never used to talk about the basic structure doctrine or how, or why that basic structure the doctrine which he now says is. Now, what we need to understand here, it appears to me that the government wants to have a larger say or a last word insofar as the judicial appointments are concerned, and for any democracy it would be a very dangerous precedent, because you don't want judiciary to become the mouthpiece of the government, of enforcement directorate. We all we all see how Enforcement Directorate is, doing raids against the opposition, and the movement.
Right. Okay. Quickly, before we lose you, the National Judicial Appointments Commission Act.
So,
right, the National Judicial Appointments Commission Act was something that was supported by the opposition at that time. The Congress also supported it, but now says that we no longer support it. But clearly, there was a thought that that there needs to be a change in the way the judges are appointed. All right, we seem to have lost Kapil Madan there, but Ashutosh, your response to this, that clearly there is some sort of thinking about the collegium system, but again, to have the Vice President first talking about the basic structure, then we have the Chief Justice of India in his speech talking about the basic structure being like this guiding star, that is something that guides us in turbulent times, and about the Constitution, how the Constitution is paramount. So you have this kind of back and forth. Do you think it's laying the grounds again for a pushback and for some sort of formal approach to this entire issue?
See, the law minister is of the view that we have, crores, around 5 crores of cases pending in the country, and which requires, the appointment of judges and filling the vacancies for the judges in different courts. And for that, we need to have the appointment at the earliest possible. So now, as per him, the collegium system is taking too much of a time, and there could be a possibility that this will get further delayed. So he is of the view that there should be reform, and if the judges
collegium has already suggested the names of judges, and it was sent back, and they have sent it back again. So the delay now, if we talk about the appointment of judges, is coming from the government's part.
See, the collegium system. See, it is something that in any democratic country, the law has to be made through the parliament, and that can be interpreted by the Supreme Court or the High Court. But in this case, what has happened, that the Supreme Court itself made the law about the appointment of judges. See, we have to adhere to Article 124 and 217 of the Constitution. What is the interpretation? That interpretation can be done. And if required, there could be a possibility of making a law if there is no clarity in the Constitution so far as the appointment of judges are concerned. Yes, the transparency has to be maintained for the appointment of judges, and if the judiciary thinks that there will be a lot of interference by the government in the appointment, there could be a way out which can be discussed, that also can be discussed in the parliament, and a law can be framed.
So
if we do not have a proper law,
to reach out to them, the opposition as well, as you said, these need to be decided in parliament, that there should be a discussion on this. As I said earlier as well, the opposition did at the time support the National Judicial Appointments Commission Act, and this was struck down by the Supreme Court. So clearly there was some support for that, and again there needs to be a conversation rather than having the law minister or the vice president coming out and criticizing certain aspects that are directed towards the Supreme Court.
See, I agree that whether it is legislature, it is judiciary, or it is the executive, in any country, all of them are very, very important factors and pillars to run any democracy, and there has to be some kind of connect between all three of them. But yes, there will be situations where there will be some kind of disagreement, but disagreement doesn't mean that there is a dispute between all these, the pillars. So what I feel that what he is saying is not unlawful. The law minister is saying is completely legal, and it is as per
but the manner speaking about the majority sane view, when you're talking about a view that you agree with, but perhaps the collegium doesn't agree with. Kapil Madan, back with us. Do you feel the government is laying the grounds with these comments in public for again opening up, and hopefully there should be a discussion on the issue of the appointment of judges? At the time, Congress also supported the National Judicial Appointments Commission Act, is what I was saying earlier. So what is your view on this?
So, Gargi, there cannot be two thoughts about it. The government wants, the reason why we are having this controversy again and again, it appears to me it's a calibrated attack, and, the Supreme Court judges has very, very, sternly has given a message to the, government officials time and again that collegium is the law of the land. The fact that NJSC was struck down being violative of the basic structure doctrine, is the law as it stands today. So therefore the government has to abide by, the law of the land. And, collegium is the law. I mean, we can't, I mean, you may not agree with it, but that's the law.
And perhaps there needs to be a discussion. Finally, Ashutosh, do you think that now with the Supreme Court, the collegium making public the discussions that were had with the government over the names and sending those names back to the government, now the government just has to accept, and do you think we will see the justices appointed to the high courts? As you said, there is a need for more judges and, for cases to move faster, and right now those names have been sent back to the government again. So do you think that now they will be appointed soon?
Yes, that has been happening and that will happen, and there should not be any partiality so far as the appointment of judges are concerned, and because that is the basic principle by which the constitution of our country can be safeguarded. Now, as we know that the Supreme Court itself has changed its verdict. Earlier it said in the first judge's case of Gupta's case, which we know, in which it clarified that the consent of the Chief Justice or the view of the Chief Justice is not mandatory on the President to appoint the judges, and it itself changed in 1993. So we have changed, we have seen the changes of the verdicts being given by the Supreme Court itself. So now, if we are talking about that there should be a concrete provision so far as the appointment of judges are concerned, I do not find anything wrong in that, and even the judiciary, executive and legislature, as I said, should come together and resolve this issue. And
rather than having this public sort of friction and sniping happening out in the public is what many feel that it's not necessary. But thank you so much. I'm out of time. Thank you so much both for joining us on this very, very important issue as this row of sorts.